Good morning. This is Eric Jorgensen with Main Street Financial for this month's rendition of The Flip Side. Today I'll be talking with Matthew Bogin, an estate planning attorney in DC, licensed in Maryland and Virginia as well. Matt, would you mind giving us just a quick overview of your practice, who you work with, and then we'll dive into the questions.
Sure, Eric. Thanks for having me on. I've been practicing for a long time in the Washington, Maryland, Virginia area. I work with all sorts of families and single people in developing and implementing estate planning strategies that will allow them to pass on both their economic value as well as their moral values to family members and others.
So, something you touched on is a great segue. You mentioned that you work with families and single people. So a lot of what I hear is, oh, I don't need an estate plan, or, I'll get an estate plan when I'm older. But it sounds like just about anybody would do well to have some type of estate plan.
Well, the reality is that whether or not anyone does actual planning, that person has an estate plan, because if you don't do anything, the state in which you live, or the District of Columbia, has set out rules about what happens to your property when you pass away. For most people don't know those rules, and then most people, when they're told about those rules, aren't in agreement with them. So anyone who has any assets and wants to make sure they go to places that you want them to go needs a plan, because if you rely on the state, I can tell you that it's not going to be the way you want it.
Okay. And what are the sort of basic things to take into consideration for an estate plan? I mean, an estate plan sounds a little intimidating, but what is it really at its simplest form?
Well, in its simplest forms is setting out what you want to have happen to your property if something tragic happens to you. And it can go from the simplest desires to the quite complex. And it depends on the nature of the assets. It depends on what your family's like. It depends on what you want to do. But you have to do something, because if you don't, as I said earlier, the state will take over the job, and it's both time-consuming and doesn't provide what most people want.
Okay. And are there any typical elements to an estate plan, things that most estate plans, or just about every estate plan, will have or should have? Sure.
Everyone needs a will, or depending on their mix of assets and jurisdiction in which they live, a revocable trust, which would serve as a substitute for the will. But they need a document that sets out what's going to happen to their property. I also think that it's extremely important to have completed what's called a durable power of attorney, so that if you become disabled but not dead, someone can step in and manage your affairs. And thirdly, I think that perhaps the most important document for many people is what some people call an advanced healthcare directive. Sometimes they call it a healthcare power of attorney. It goes by various names, but it sets out, first of all, who's going to make medical decisions if you can't, and then and second of all, gives them some guidance as to what those decisions should be. And so for me, those are the three key elements. Then, depending on, of course, the mix of assets and tax law, there can be other kinds of trusts, but I think that's perhaps beyond the scope of what we're talking about today.
Yeah, and I can tell you from personal experience, when I lost my wife and everything happened, not having a healthcare proxy, it made things difficult, made those decisions even more difficult to make. Whereas if she'd at least had something in writing that this is what I want, I would know unequivocally, rather than just
Yeah.
a discussion we had or whatever.
Yeah, absolutely. It's you don't need those documents, and particularly that one, until you need it. And then when you do, it's always an emotionally laden situation, and sometimes decisions have to be made quickly, and you just want to make sure that you've done at least the minimum to allow somebody to make a decision that you want, because you don't want people making healthcare decisions that you don't want.
Right. And so power of attorney, when I was active duty military, we had people we gave power of attorney pretty frequently to pay our bills because we were deployed. And I saw opportunities where it went less than desirable. So what are some things people should be thinking about when they give that power of attorney, and what are you really giving when you give somebody a power of attorney?
Well, you are giving somebody the authority to stand in your shoes, so to speak, and do all that you can do with your assets. Now, there are kind of two variations on the durable power of attorney. One's called a springing power of attorney, which means that it springs to life at some designated event. The other is a power of attorney that becomes effective immediately. Both of them have drawbacks. In the springing situation, oftentimes it'll say, when two physicians say that I'm incapable of taking care of my affairs. So sometimes it's hard to find the two physicians. Sometimes you get letters from two physicians and you go to the bank and a teller who's perhaps not the most sophisticated individual says, well, it doesn't say what it's supposed to say, even though it's different language. So springing powers of attorney present those problems. Immediate powers of attorney, as I said, take effect immediately, and they allow somebody to step in your shoes. Now, they can only do that if they have the original, at least in the case of real estate transactions, or if they even have a copy of the document. So sometimes what I do with clients is hold on to the originals and don't distribute copies. Now, that also presents a problem, because when somebody needs it at 11 o'clock at night and I'm home sleeping and I can't get it to them, that presents a problem. But the basic issue is picking somebody who you trust. And it's also true that powers of attorney are abused, and more often than not, they're abused by family members rather than, if you will, strangers. So that you want to think about it. In the case of spouses, it's usually okay. But as people get older and can't necessarily make great judgments, they need some guidance.
Okay. And along with that, you mentioned having the documents, and you should give people the original. It just brings to mind that I've had people tell me that they're going to keep their wills in like safe deposit boxes and things of that nature. And I think that's a concern, right? I mean, if it's in a safe deposit box and you need it, it would, you can't open a safe deposit box before probate, correct?
Well, okay. So a safe deposit box is not necessarily the optimal place to keep your will. If it's a married couple and the marriage is intact and both wills are in there, and presumably there's not a joint disaster, so one spouse can get in with the key. Otherwise, I tell people that if they're going to keep it in a safe deposit box, they need to have another person or other people with signature authority and keys to be able to get into the box, because otherwise, yes, the box gets sealed and you have to get an order from the court, register wills, whatever, to be able to open the box.
And that's pretty cumbersome in an event when you.
Well, and it takes time, which is maybe not that important, but it costs money, which is always important.
Right. And so let's say I've got my estate plan. I put it together a couple of years ago. Haven't thought about it. It's been on autopilot. When should I be thinking about it? Is that something I should be taking out, dusting off every couple of years just because, or is there triggering events, or a little bit of both?
Sure. Well, I think it's a little bit of both. For example, if you have minor children, and I often have the situation where they've the parents have nominated a guardian in their will, and now that person is they're not getting along with the parents, or they're no longer in the family for whatever reason. So that's one. Another is that again, with children, it's my view, and it's not an original view, that children shouldn't receive inheritances at too young an age. So oftentimes, not oftentimes, always, we have a trust in the will for the parents of minor children. Now, sometimes it says that the children will get the money at 25, and now they're 20, and you realize that either A, they're mature and able to handle the money, so maybe you want to cut back the age, or B, they're not mature and can't handle the money, and you want to increase the age. Big life events, obviously. I often get calls from clients who unfortunately have lost their parents and have inherited some money. Then there's changes in the tax law. Thinking about it, no one really wants to think about it ever, but thinking about it at least every 5 years is a rule of thumb, as well as significant life events. Sorry.
And so that echoes my sentiment with regards to inheritances and how much money you should be leaving, or at what age you should be really giving children money. I know at 18 you're technically legally an adult. However, from a financial planning standpoint, I really don't want to see my clients leaving large sums to an 18-year-old. I mean, there are going to be rare occasions where that 18-year-old is going to be in a good place. But more times than not, I'd rather see the age 25 or 26 or something similar, because as you mentioned, they can always go back and change it to be younger if things are working out differently.
Sure. And also, at least in the documents I do, the trustee has some discretion to disperse the money earlier. So if something happens and the person's mature, that the trustee has the discretion to do that. But the trustee doesn't have the discretion to hold on to the money if it says pay it all out at 24. Mm. So I tend to suggest older ages.
Yeah, because that makes a difference between buying a Corvette at 19 or, versus maybe they need the money because they're going to put a down payment on a house at 22.
Correct.
And that would be a more constructive reason to take the money.
Correct. And I just happen to have a client who just bought, who's not 18, but he's not 25 either, and he did just buy a Corvette because there wasn't a good plan in place. It's a great car. It's a beautiful car, but
yeah, I had when I was in my early 20s, I had a 1978 Corvette. It was a wonderful car. Just I could have done something much more constructive. Right. So, we review the estate plan, or we've got people thinking about, we need to do an estate plan. We have young children. We haven't really discussed a guardian, or maybe we don't have young children, but we don't have anything in place. And we know we should be meeting an attorney. What are some things that a dialogue that they can have between themselves before they sit down with you or another attorney, just to make sure when they get there, it's a really efficient use of time, and they're not walking out going, man, I wish I'd known this before.
Sure. Well, I think the number one thing that people should talk about, if they have minor children is, who do they want to be the guardian if something happens to both of them? And I can tell you that I've had situations where people have procrastinated for 3 or 4 years because the wife says, well, your brother can't do it, and the husband says, well, your sister can't do it, and it never gets done. And so along with everything else in life, sometimes compromises are in order, but that's really something that needs to be thought about, because it just stops. When I say, well, who do you want to be the guardian, and then a backup, and it just stops the process cold. It's a lot to think about, and when you're thinking about not being there for your kids, it's pretty emotionally difficult to begin with. So having discussed that, then thinking about, obviously, how you want to distribute the money. And again, if it's a family with young children, and usually each spouse wants the other one to inherit and then the kids, but not always. And certainly in divorce situations, it gets complicated, and a large number of marriages end up in divorce. And then sometimes there's family members with special needs and how to plan for them. And then it's not, I don't want to say it's frequent, but it's not infrequent that I get the situation, well, I want to devote, my mother's 90 and might need some money, so I want to devote some money for her. And how do I do that? So, thinking about clearly the guardian, and then thinking about your goals and your desires before you talk to a lawyer makes it a more efficient process.
And I just like to add a little bit of 2 cents to the guardian piece. Before, it's great that, especially when husband and wife agree, but I would chime in that they need to make sure the guardian is agreeable and is willing to take on that as a responsibility. I mean, I guess it seems a little like common sense, but
no, I often have that conversation. Well, I haven't, we've decided on whatever, your brother, but we better check with him first. Yeah, I mean, it's a big responsibility. It's and
especially if you have a child with a disability, that could potentially keep, and that the individual would need care beyond 1920 and into their 40s or 50s.
Well, sure, that's right.
So, what are some of the objections that you find yourself trying to overcome, or reasons that people would make justifying to themselves why they may not need an estate plan? Those little things I think we all do about why we're not necessarily doing what we should be for ourselves.
Well, sure. Well, and obviously the first thing that when you talk to people, they say is, well, I'm not going to need that because nothing's going to happen. And eventually something will happen. If something happens to somebody every day, but it doesn't happen to everybody every day. The second is I don't have enough. And particularly in this area, a lot of people who don't think they have enough really have more assets than they understand. And retirement asset planning is not really part of this discussion, but there has to be a lot of people have money locked up in retirement assets as well as life insurance, and that all has to be coordinated. And when you start telling them, oh, and all of a sudden the numbers get to be a lot bigger than they thought. And then the third is, of course, that it's too expensive. I don't think it is. I think first of all, if you have a child, what's too expensive? Because I can tell you that it's less expensive to have a will that nominates a guardian than if something happens to you to have someone have to go to court and get the court to appoint a guardian. And there's many more restrictions, and it's much longer, and it's just not worth it. So, and then there's everybody's pressed for time, but it really doesn't take that much time. And if you deal with somebody who's a lawyer who's experienced, the lawyer can help expedite things. So
And
I think that's it.
if they wanted to call you, I mean, if they wanted to call to get an estimate for how long it would take, or what it would, what their circumstances would require, is that something they would be able to do? Would they be able to call you and say, "This is my circumstance. What type of plan would I need?" Or how would they?
Well, my process maybe is a little different. I think it's important for the clients and for me to meet face to face. Now we're doing a video chat, and maybe that's an intermediate way between a face-to-face in-person meeting and a telephone call. But I think part of this is that I want the clients to trust me and feel comfortable with me, and I want them to be frank and open with me. And I think just doing a phone call doesn't overcome some of those barriers. Plus, everybody's money is important, but I'm not sure shopping on price in this area is the way to go. Now, that doesn't mean you should pay $50,000 for an estate plan if you don't have the assets that justify that. But I think calling a bunch of people and saying, "Well, I need a simple will." I mean, clients always tell me I need a simple will, and it turns out, they've got children, they've got life insurance, they've got retirement assets. It's not a simple will. So calling people and saying, "What do you charge for a simple will?" is, in my view, not going to get the best result.
Yeah, and when I talk to my clients, it's first of all, an estate plan is part of every financial plan because it's just important. It's really, really important that people understand what each other wants in the event that something happens, and that it's, to your point about the retirement accounts, life insurance, and things like that, making sure it's going to the right place. But it's, I am not a fan of, let's just go cheapest because that's always the best route. And in my opinion, when you start talking about making an investment in yourself or in your future, which is what an estate plan is, a financial plan is, it really needs to be more about, to your point, can I trust the individual I'm working with, and are they going to be able to speak to what I need and meet me where I'm at?
Right.
That's what I think is more important than, obviously, if somebody's out there charging an exorbitant amount of money for an estate plan, then sure, that should be a problem. But I think it's reasonable to expect to pay for time and the professionalism and the experience. You don't want to work with somebody who's never seen this before, right? And that ties into special needs. I work with a lot of families. I work with veterans and families with special needs. That's my passion. And an estate plan for an individual with special needs or a family with special needs is not the same as a traditional estate plan. Or maybe parents or aging parents losing capacity. And, so can you touch on that real quick as we're winding down, just some considerations to think about for those circumstances that, it's important everybody gets one, but it's even more important for situations like special needs or aging parents,
Well, sure. I mean, if there is a child with special needs in the family, that, first of all, presents additional financial burdens. But it also, you need somebody who understands all the eligibility requirements for benefits from the government. Now, the benefits from the government aren't overwhelmingly great, but they're important, and some of them cannot be replicated. You could be Bill Gates, and you can't replicate this, pay for the services. So it's really important to understand that. It's also to understand. I spent a lot of time representing families with special needs in all kinds of different areas, and it's not just sufficient to say, "Oh, well, yes, special needs will do this." You have to understand what those needs are, because there's differences. So that's really important. And then with aging parents, that presents other challenges, because we want to make sure that they're being taken care of and that their money is being protected. At the same time, you don't want to take away more independence than is appropriate. So again, you need somebody who's had that kind of experience. And those are both difficult situations, but they have to be dealt with.
Mm-hmm. And in my personal opinion, my preference is to work with somebody who understands it and is willing to push a little bit, because sometimes you need a little push to get over the inertia, right? I mean,
sure. And particularly with the families with special needs, you have to have somebody who has a little empathy too,
yeah.
and understanding, because it's a difficult situation, and not all children with special needs are the same, and so understanding that is really important for people with special needs, not just children, because it doesn't go away when they become adults.
Right. I mean, in a lot of ways, there's a lot of benefits. There's a lot of attention for younger.
Yes.
And then they turn 18 or 21, they leave the school system.
Yeah.
And holy cow, there's that precipice.
Yes.
But
yes.
That's a whole different topic. And
yeah. I mean, just to say, I have a lot of clients whose children are sitting in the basements playing video games and can't do very much. Can't find much else to do. Yeah. That's a bad situation.
So I appreciate your time today, Matt. Is there anything I should have asked that I didn't, or any last thoughts that you'd like to put out there in closing?
Well, I think you asked all the basic questions, and again, in closing, I think that people need to realize that if they don't do anything and something happens to them, there's a plan. And just as an example, if I have a client who I did a will for, but neglected to tell me that a $1 million life insurance policy that he left to his 2 minor children, and that's causing all kinds of problems. So I think the moral of the story is you need to do something, because if failing to plan is planning to fail.
Exactly. I was going to say that exactly.
And you don't want that in this kind of situation.
Well, thank you again. Matthew Bogin, estate planning attorney, licensed DC, Maryland, Virginia. His contact info, Matt, do you mind shooting out your email or the best way to reach you real quick? And
sure. Well, my phone number, since we're still using those occasionally, is 301-656-1755. And my email address is Matthew, MATTHEW, .Bogin, BOGIN, @boginlaw.com.
Awesome. Well,
thank you.
Thanks everybody for watching. Again, this was Flipside with estate planning attorney Matthew Bogin. Have a great day.